attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series discussing NASDAQ listing requirements. And in particular, today I am going to talk about the seasoning rules. The seasoning rules were adopted in late 2011 by multiple national exchanges, including NASDAQ, in response to a request from the SEC for the exchanges to limit the ability of companies to uplist following the completion of a reverse merger transaction with a U.S. public shell company. The SEC request came as a result of a slew of reverse mergers from Chinese entities where the representations related to the financial condition of the Chinese foreign companies turned out to be fraudulent. The seasoning rules prohibit a company that has completed a reverse merger with a public shell from applying to list until the combined entity has traded on the U.S. over-the-counter market or on a regulated foreign exchange for at least 1 year following the filing of all required information about the reverse merger transaction, including audited financial statements. The rules also require that the new reverse merged entity has filed all of its required SEC reports for a 1-year period, including at least one annual report on Form 10-K. The seasoning rules require that the reverse merger company maintain a closing stock price equal to the stock price requirement applicable to their particular initial listing standard for a sustained period of time, but in no event less than 30 days of the most recent 60 trading days prior to the filing of the initial listing application. The rules do have an exemption for companies, or an exception for companies that complete a firm commitment underwritten offering, resulting in net proceeds to the company of at least $40 million. In addition to the specific additional listing requirements contained in the seasoning rules, the exchange, like NASDAQ, may, in its discretion, impose more stringent requirements for companies applying after a reverse merger if it believes it is warranted based on, among other things, an inactive trading market in the reverse merger company's securities, the existence of a low number of publicly held freely tradable shares, if the reverse merger company has not had a Securities Act registration statement or other filings subjected to a comprehensive review by the SEC, or if the reverse merger company has disclosed that it has material weaknesses in its internal controls and has not yet implemented an appropriate corrective action plan. Although the seasoning rule only applies to reverse mergers with a shell company and not an existing operating business, in my experience, NASDAQ will take the position that almost all reverse mergers are completed with a shell company. Even if the company itself has taken the position that it's not a shell and has not been challenged in that respect by the SEC, FINRA, DTC, or any other regulator, NASDAQ can and will make its own review and determination on the point. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.